Hi, everyone. Welcome to another episode of the Ask Amity Show. And today we want to talk about the top 3 myths of the estate planning process. So, are you aware of these estate planning myths? Previously, we discussed how people think that having a living trust means that everything is permanent and you cannot make any changes to it. You can watch this episode by clicking on the box above. Today, we discuss more common misconceptions that people often have regarding estate planning, trusts, and wills.
Yes, and the first myth is that estate planning is only for the wealthy. Oftentimes we see in TV shows and movies, it shows us that wealthy people are the ones who have attorneys that they contact about updating their trust and estate planning documents. But in actuality, the truth is that if you own property or any assets and you have loved ones that depend on you to provide for their income or care, then you really do need an estate plan regardless of your estate size. So what does an estate plan do for you? So it really does accomplish a lot of important goals to help maintain your family and protect those who depend on you. So one of the things is that it does protect those who depend on you and your income during their lifetime. You can name a guardian for minor children. You can name family members, loved ones, and organizations that you wish to receive your property following your death. You can, transfer certain properties to your heirs and any organizations you've named in your estate plan in a tax efficient and expedient manner. And then, with as few legal hurdles as possible. You can also manage certain tax exposure. There's a lot of things that you can do through an estate plan, including, naming an executor or trustee who's going to be the person who settles your estate and distributes your property. And most importantly, with an estate plan, you can avoid probate, which is a court process proving that a deceased person's will is valid or estate plan is valid. If they don't have an estate plan, then again, probate also helps to determine who your heirs are. And then document the type of care you prefer if you become ill or incapacitated, including life prolonging medical care if you do or you do not wish to receive them. And you also can express your wishes and preferences for funeral arrangements and how related expenses will be paid.
So myth number 2 is a will can oversee the distribution of all my assets and it is perfectly adequate. The truth is there are certain assets that may sit outside of the will. These include life insurance policies or qualified retirement accounts, 401ks, IRAs that have a beneficiary designation, as well as assets or accounts with a pay on death or transfer on death designations. These assets transfer directly to the named beneficiaries and are not subject to probate. Moreover, what is the truth of that? The real truth of that statement is that a will is not adequate, especially if you have assets in California, above $166,000. And if that's the case, you want to make sure that you do some more advanced planning and do a trust rather than a will, because a will require those assets to go into probate.
Yes, and then myth number 3 is once I complete it, I can just leave it to be. So the truth is planning is never a once and done proposition. Like life, your preferences, your goals, all of those change over time and also may be impacted by outside influences such as financial markets, tax law changes, and economic events. Also, personal situations may change if you got married or divorced, welcomed a new child or grandchild, when your minor children become adults or you move to another state. Also, if your spouse passes away, all of these changes may need to be reflected in your estate plan. So it's very important to periodically review your estate plan and update those changes, including beneficiary designations and how, your various accounts are titled. So simply updating your living trust or will after a life event doesn't trigger automatic updates to all of your other legal documents. So you need to make sure each one, such as your power of attorney, is updated with new information. And, you know, honestly, the most common oversight that we see is forgetting to change beneficiary designations on life insurance policies. So those are all things that we would be able to continue to have this discussion with you. What we offer is, you know, annual reviews with our clients if they do their estate plan through our office, and we'd be happy to talk to you about, you know, all of your changes, any life events, any things that you want to be concerned about. We'll kind of advise you as such. So feel free to reach out to us, and don't forget to subscribe to our channel, Ask Amity Show. Thank you very much. Bye, everyone.